The focus of our webinar today is the changes that are happening in the California bar exam. California bar exam is changing effective this summer, July 2017. So what we'll talk about in this webinar is how and why it's changing, and more importantly, what's different about preparing for the exam than the previous format, and also what's the same about preparing for the exam compared to the previous format. So it's effective July 2017 is when the bar exam in California is changing. This was actually under consideration for a number of years. Various proposals had been floated for how the exam might be modified. And after a number of years of considering these various alternatives, the Board of Bar Examiners made the decision, and it was announced in August of 2015, 2 years ago, with an effective date of this summer, July 2017. And going forward from this summer, they'll continue to use the new format. So before we get into the how, why is the bar exam changing? California bar exam for many years has been one of the most difficult bar exams in the United States, one of the lowest pass rates every administration among the states. And this raised a number of concerns, including whether the exam was too difficult, whether it was too long, and in particular, because the California exam was 3 days long, as we'll discuss shortly, there was an awful lot of grading that had to be done to get these scores back in a timely manner. The Committee of Bar Examiners in California had to hire a large number of graders because California is our largest state in terms of population, largest exam in terms of the number of people who take it every administration, and a lot of grading to be done. Obviously, they don't want people to have to wait too long to find out whether they've passed or not. They were trying to figure out if there are ways they could change the exam to address some of these concerns, both by people taking the exam and the committee administering the exam. So as part of this process, they reviewed a lot of data from their previous administrations of the bar exam. The main proposal, the one that got adopted, was to shorten the length of the test. So they went back and looked at the scores on the various components of the California bar exam from their previous administrations, and their conclusion was that they could shorten the exam without compromising the validity or the reliability of the results. In other words, that each individual exam taker's score and their pass-fail result on the test was going to be the same under the new format and the old format, that they didn't need the additional content to correctly identify the passers and failures in each administration of the bar exam. And so given that their data confirmed this conclusion, they went forward with the change in reducing the length of the bar exam because they didn't need the extra time and the extra questions to make those determinations of who should pass and fail. So how did they change the exam? Well, first we'll talk about the previous format. This has been used for many years, up to and including the February 2017 bar exam. As I mentioned, the California bar exam was 3 days long. That by itself makes it very challenging because most states have a 2-day bar. It was 3 days long. 1 day was the MBE, the multi-state bar exam, 200 multiple choice questions in 6 hours on a variety of topics, traditionally 6 topics, more recently now 7 topics. But the standardized multiple choice law exam that all of our states use. That was 1 day. The other 2 days were the written component of the California bar exam. Again, the previous format was 6 one-hour essay questions and 2 performance test questions that were 3 hours in length each. So 6 hours of essay 1 hour each, and 6 hours of performance test questions split in half, 3 hours and 3 hours. We'll talk a bit about what performance test questions look like toward the end. So the way they arranged this test over the course of the 3 days was to have the MBE on Wednesday, which is the same day it's held nationwide for exam security purposes. The MBE exam is held on a Wednesday. In other states that only have a 2-day exam, they could put the other day on Tuesday or on Thursday, but California used both. So California put the MBE in the middle, and then on Tuesday and Thursday, they would have 3 essay questions in the morning for 3 hours, and 1 performance test question. The entire 3-hour afternoon segment of the bar exam was a performance test question. And they repeated that on Tuesday and Thursday. So the 3-day exam had this format of the 6 essays, the 2 performance test questions, and the MBE. Made the exam quite long in endurance to take it, and a lot to grade. They had to grade 12 hours of written material for every single person who took the test. And this led to the shortened new format that takes effect in a couple of months, July 2017. The new exam is 2 days long rather than 3. It keeps the MBE because California, like the other jurisdictions, wants to still use the MBE. So it keeps the MBE and reduces the written component of the bar exam from 2 days to 1. It reduces the essays from 6 to 5 and reduced the performance test questions dramatically. Instead of 6 hours of performance test questions, it's now 90 minutes, an hour and a half in 1 question. So they considerably cut down the amount of time allocated in the test to the performance test questions. They kept the MBE as is, only took out 1 essay, and really trimmed down the performance test. So this July, California exam is going to look very much like other states. State day, the California day, will be on the Tuesday with 3 essays in the morning, then the break for lunch, and then 2 essays plus the performance test in the afternoon. So that will make for 6.5 hours that day rather than 6, but it reduces an entire day in the exam. And then the Wednesday will be the MBE as it was previously. So we have this very substantial reduction in the length of the test and the scope of the test. So, thinking about preparing for the exam, how does it change the way we think about preparing for the bar exam now that the California bar has changed to this new format? So our 3 big takeaways that we'll walk through. The MBE and the MBE subjects are more important than they used to be in passing the California bar. The essay questions, which were pretty significant previously, remain very significant to succeeding in the California bar. The performance test questions have been substantially reduced in length and in importance. And that affects the way that people planning to take the exam have to prepare, because you're spending a lot less time during the test answering performance test questions than previously. And of course, the exam is just 2 days rather than 3. So walk through each of these 3 points one by one. The MBE subjects are more important than previously. California bar examiners previously had released the distribution of the 3 sections of the exam, and previously the MBE was about 35% of the total score on the California bar. Effective this summer, the MBE is now 50%. The MBE is 50%, and the written component is 50%. So 15% of the total score has been reallocated to the multiple choice, 7-subject, nationwide MBE exam. This means that there's less opportunity than there was before to make up for a weakness on the MBE test by strength in the written component of the exam. Previously, the written component was 65%, and high scores on some essays or performance tests could compensate for a lower score in the MBE. Now that's not going to be as possible because the MBE is now half the score. So for test takers who struggle with the MBE subjects or who struggle with the multiple choice test format, this may make the exam harder because the MBE is now up to a full 50% of the score rather than 35%. In addition, on California's essays, which we'll discuss more in a minute, they didn't only discuss California state law topics in their essay test questions, they also tested MBE subjects in the essays. Previously, when there were 6 essays, there would usually be roughly 3 essays on MBE subjects and 3 essays on California subjects. It varied a little bit from administration to administration, but it was roughly 50-50. So studying for the MBE topics was not limited to studying for those multiple choice questions. It also involved preparing for the ways in which those subjects might be essay tested. And it's likely that they will continue to be essay tested. So MBE subjects may actually end up being more than half of the total exam score, whereas before they would not have been. So to succeed on the California bar exam new format, it's going to be really important to be well prepared on the MBE exam and the subjects that it covers, both on those multiple choice questions and the essay questions. The MBE and its subject matter is more important than it used to be. In terms of essays, they remain very significant in passing the exam. In the previous format, they were slightly less than 40% of the total score. And the California bar examiners haven't specified exactly the distribution of points between the 5 essays and the 1 performance test in the new format, but given the amount of time, 5 hours versus 1.5 hours, it's likely that the essays will be proportionally rated in the points, and that would keep them around 40% of the total score. The essays are important because they test not just the MBE subjects, but also a variety of state law subjects. And California, which does not use the uniform bar exam or the multi-state essay exam, they use their own state-generated questions, has heavily tested the state law distinctions in the past. Although they do have some questions on MBE subjects, on general principles of national or federal law, a significant number of their essays are on state law and state law distinctions, particularly in some subject areas where California has some big contrasts with other states. California's community property law in family law and marital property law is very different from most states, and it's heavily tested. California also has a number of significant distinctions in wills and succession of property after death, and that is frequently tested. And California has its own code of professional responsibility, the rules of professional conduct applicable to lawyers as well. And California frequently tests those California professional responsibility rules. And given how frequently they tested these state law topics and the state law distinctions in the past, I think a fair prediction that they will continue to frequently test these types of questions on the new format. My last bullet point on this slide is a hypothesis. We won't find out for a few years' worth of administrations. But with the increased weight that's given to the MBE multiple choice score in the total exam, it's possible that the written component of the bar exam might de-emphasize the MBE topics in favor of state law subjects. As I mentioned, in the past, those essays tended to be about 50-50 between MBE national topics and California topics. And the performance test questions varied between state law and federal law topics as well. But now that they've reduced the amount of time in the written component, it wouldn't surprise me if more of the written component focused on state law, now that the MBE is more important. As I said, we won't know for sure until we see some released questions from upcoming tests to see what they've done. But they really like to test state law distinctions in the past, and I anticipate they will continue in the future. So if we think about the topics that are tested on the MBE and in essay questions, you can see how it breaks down. I have 3 columns on this chart. The left-hand column is the multi-state bar exam subjects. 200 questions in 6 hours on the MBE are drawn from these 7 subjects. They are typically required courses in U.S. law schools, and they're the foundational material in the legal curriculum, so they're heavily tested on the MBE. And the questions are essentially roughly split in allocation in 1/7 on these topics. So the topics in black are topics that are tested on the MBE: torts, real property, contracts and sales, which includes the Uniform Commercial Code, criminal law and criminal procedure, federal constitutional law. There's 2 other topics that are tested on the MBE: federal evidence and federal civil procedure. I've marked those in blue because those are topics where there are California distinctions with California civil procedure and California evidence. Of course, again, the MBE will only test those federal rules, federal principles in the 7 MBE subjects. The California essays might test California civil procedure rather than federal civil procedure. There have been some questions testing federal civil procedure on the essay, but more frequently when they test civil procedure, they've tested the California distinctions. Same thing is true for evidence. There have been some essay questions that involve federal rules of evidence in an essay, but more commonly, questions testing evidence in an essay have tested California evidence. Then there are these other 3 topics where California distinctions are heavily tested. California community property is tested quite frequently, not every administration, but pretty much every year, either July or February, there's been a community property question in recent years. California wills and succession also, many distinctions. California does test the law of trusts as well as wills and succession, but not with distinctions. They just test general principles of trust. California law is not distinct enough from nationwide principles for the bar examiners to test California distinctions there. There have been questions involving trusts, but where general principles are enough to answer the question. The last area with the distinctions I mentioned a minute ago, professional responsibility. essay questions test the California rules of professional responsibility, as well as the ABA model rules of professional conduct. And some of the essay questions on the California bar exam have asked exclusively address the California rules of professional conduct only. A number of other essay questions have asked for the answer to address both, apply both ABA and California authorities, specifically asking in the question for the answer to compare and contrast the ABA and California rules, where they are the same and where they are different. The colors in red, the topics in red on the right-hand column, are topics that California tests on their essays, and they test general principles. They test remedies quite frequently, and they test corporations, partnerships, and other business organizations. So, again, on the essay topics on the exam, we can expect some amount of questions on MBE subjects. I would be surprised if they eliminate MBE topics entirely from the essays on the upcoming test. But we could also expect some substantial treatment of the state law topics, some from the column where there are distinctions, and some based on general principles. So there might be a question involving a will and a trust, where we have to apply California principles of wills and regular principles of trusts. Or, as I said, California and ABA rules of professional conduct both together. And of course, questions can be a hybrid question on multiple topics. So, for example, there have been questions where half of the question is about contracts and the other question is about remedies, or half the question is about whether a tort occurred and the other half is about the remedies. There can be interactions between civil procedure and evidence, or torts or contracts, or criminal law with evidence. Wills and trusts goes together quite well. Wills and community property also goes together quite well. There have been a number of questions in recent years combining professional responsibility and either corporations or partnerships. So we have to keep in mind that as we study these topics, we're not simply studying them in isolation on single topic questions, but there could be hybrid questions combining these two different topics from this list. So the MBE is very important because it's the multiple choice, as well as some of the essays, and then the state law topics on the essays. The last component of the California bar exam is the performance test questions. Previously, they were about 25% of the total exam score. Even though they were 1/3 of the time, they were about 25% of the score. Now, estimating it's probably more like 12% of the score. It's likely to be proportional. The amount of time that's been allocated to performance questions is where they trimmed out the length of their exam. They reduced the amount of time allocated to these performance test questions from 6 hours to 1.5 hours. They did this because they realized they didn't need all of that time to effectively test what they were trying to evaluate in the performance test questions. The interesting aspect of this is that California originated the idea of performance test questions. California Bar, they created the idea of performance test questions and implemented them, and they implemented them in this format we talked about. The 2 performance test questions for 3 hours each as part of a 3-day exam. Other states and the National Conference of Bar Examiners really liked the idea of performance test questions, and we'll talk through what it means momentarily. They really liked the idea of the performance test questions. And they said, this is a type of question we think is a good idea to include. But these other states and the National Conference of Bar Examiners that writes the MBE and the MEE also created a MPT, multi-state performance test. But they disagreed with California on the length. These other states were not willing to go to a 3-day exam. And so they needed to come up with a format that would allow them to keep a 2-day exam. So the NCBE and the states settled on a 90-minute performance test question. You could either do one question for an hour and a half, as California does now, or you could even do 2 for a total of 3 hours and have fewer essays. But the 1.5-hour length was the consensus. The idea that a 1.5-hour question was long enough to successfully test what they were trying to evaluate, but not too long. So over time, California became the outlier. Even though they originated this format of question, they were superseded by the actions of all these other states and the MPT in their format. So what has happened now, effective July 2017, is that California has come into conformity with what everyone else nationwide is doing. They're basically saying, you know what, you're right. We don't need 3-hour length questions. We don't need 6 hours of these questions. A single question for an hour and a half is enough to evaluate what we want to test in these questions. Okay, so it's worth talking for a minute then about performance test questions, because most state bars still don't have them. Most state bars are still the MBE and then essays. So what is different about a performance test question? In a traditional essay, you're given a fact pattern and you're writing up the analysis of what the answer is. In a performance test question, you're not coming in with your memorized knowledge and applying the law that you already know to a new set of facts. Rather, a performance test question is asking you to act as a lawyer does in practice. That's why it's called performance test, performing as a lawyer, not simply using the knowledge you've already acquired. So in practice, lawyers are assigned a particular task with an identified goal. They're not just given a fact pattern and said, here, tell me what the answer is. They're given a task. Look into these facts, look into this law, figure this out, and then create a certain kind of work product. An identified goal, not just simply reasoning through the answer, but solving a client's problem or addressing a client's issue. So a performance test question consists of 2 types of materials. Unlike an essay question, which just has a fact pattern that's laid out for you on a page, you're given a set of materials to work through, and they are called the file and the library. And this is modeling what lawyers do in practice. They get a file with a client's problem, and they have to familiarize themselves with that problem. They read the file, whatever documents might be in that file, and figure out what's going on. And then, either literally or metaphorically, they go to the library and they research what the applicable legal authorities are to determine what the solution to the problem is. So that's what the performance test models. You get a file. It's similar to a fact pattern in the sense that it provides the factual scenario of the problem, but it doesn't do so in a narrative piece of text telling you a story, here's what happened, tell me what the answer is. Rather, they give you model documents. Here is a letter from the client. Here is a letter from the opposing lawyer. Here is a memo or notes from a phone call or a meeting. The factual scenario is one that you have to unpack from the materials in front of you. It's not just a narrative you can read. You have to read through the materials in this file and figure out which facts are important and which facts are unimportant, which facts are distractions. In addition, the file will give you your specific instructions. It will tell you, here is the file, and here is the kind of work product we need. And these performance tests vary. Some will say, write a letter to our client, telling them how they can expect their case to be resolved. Or write a memorandum to the opposing lawyer explaining our position. Write a memorandum of authorities to the judge explaining our position. So it could be a litigation document, it could be a piece of work product, a memo within the firm, a letter to a partner, a letter to an opposing lawyer. One thing the file will always do is provide you with a sample of that type of document so that you can use it as a model to know what type of work product you're expected to produce. The other thing that's different about performance tests is the library. In the MBE, in essay questions, you're expected to have the law memorized and be able to come in, read a fact pattern, identify what the legal issues are, and state the answer based on the law that you've memorized. The library is the opposite of this. The library provides you the legal authorities. It says, use these legal authorities to address our problem. And those are the only legal authorities that you should rely on. You're not allowed to draw upon your outside knowledge. You're supposed to use only the material in front of you. It may be excerpts from case law. It may be statutory language or regulations. It may be a memorandum summarizing law, but you are given the legal authorities, and then you have to parse those legal authorities and figure out which are on point, which are distinguishable, which authorities in our library help our claim, and which ones hurt our claim. Because you are given these materials in the library, performance test questions are not limited to the subject matters in the MBE or even the subject matters on the California state law topics. Often they will be familiar just because they don't want it to be completely left field, but it might involve something like copyrights and intellectual property, or an injunction, or a temporary restraining order. Some topic that would not normally be tested in the multiple choice or essay questions, they can give you the authorities that you use to resolve the problem. In other words, they're testing your general legal analysis and reasoning, reading and writing skills, not your display of previously acquired knowledge. So how does this differ? So again, by comparison to an essay, it's quite a different task. In an essay, California's essays are almost exclusively one page long, single-spaced, but one page, or sometimes even less, sometimes closer to a half a page. Not all that many words to read, a single-page fact pattern with a number of issues embedded in it. And the idea here is that you have 1 hour to do this question. So you have a page to read. You probably spend about 10 to 15 minutes reading that fact pattern, reading it several times, identifying the issues, remembering what the legal principles are, outlining your answer before you start writing so you have a plan of attack, and then spending about 45 minutes writing the answer. California Committee on Bar Examiners releases sample answers for their previous exams. They release the previous exam questions, and they release sample answers. They're not model answers. They're not necessarily an A+ answer, but they are answers from examinees who took and passed the exam on the first attempt. And what we learned from these sample answers over the years is that these sample answers are about 4 to 5 pages long. Now, they sometimes are printed single-spaced. They could be printed double-spaced. You're looking at about 2,000 words. So 45 minutes of writing to produce 2,000 words. That's actually not a particularly quick pace of writing. Of course, if English is not your native language, it can be challenging to write this quickly. But the bar exam is written with American native English speakers in mind. So writing 2,000 words in 45 minutes is roughly 40 or 45 words per minute, which is a very reasonable pace. You don't have to type frantically, extremely fast to put enough words on the page. But you do have to be able to read the fact pattern and analyze it quickly and have the law memorized so that you can apply it quickly and spend only that 10 to 15 minutes preparing to write. That's how it works on an essay. Performance tests are different. Now, because the new format takes effect in July, we don't have any previous questions in the 90-minute format from California. We've only got the 3-hour format. They did release one sample question, and it confirmed what I expected, which is that the 90-minute questions will be half as long. This makes sense, obviously. So it's half as much material. So the file will probably be about 5 to 7 pages of material to read. And then the library will be an additional 7 to 9 pages. So 12 to 15 pages, a lot of material. Now, some of this will be double-spaced. It won't be as dense as the essay. But there's a lot of material to read because you have to read the file very carefully and figure out what are the important facts. And then you have to read the library carefully to figure out what are the legal authorities. Do I understand them? I have to synthesize them to figure out which ones are important and which ones aren't. So it's a very challenging task. And this is why, based on the MPT's questions and answers, based on the California 3-hour answers before, the way to approach performance test question is you're going to spend half your time preparing to write. Because the sample answers are about the same length as essays. They're about 4 to 6 pages, about 2,000 words, which is comparable to 45 minutes of writing. So the difference between a performance test and an essay is not the length of your answer. It's the length of time you spend before you write your answer. On the essay, 10 to 15 minutes preparing, 45 minutes writing. On the 90-minute performance test, 45 minutes preparing, and then 45 minutes writing. A long time. There's 12 times to 15 times as much to read. You need a lot more time to read, analyze, and then figure out what you're going to say. How am I going to parse the facts? How am I going to synthesize the legal authorities? So it's a very different type of skill than an essay, where in an essay I'm simply displaying the knowledge that I've already memorized. In the performance test, I'm handed a case I've never seen before. I've handed legal authorities that I've never seen before and asked, read this file, read this library, and figure out what's going on. So performance test questions have been substantially reduced in importance. So this is good and bad. But for many people who took the exam previously, they found these questions to be very challenging, precisely because they are so different from what traditional law school exams ask you to do, both in terms of content. You're being tested on material you haven't seen before rather than material you've memorized. And also in how you approach the answer, because in an essay you just explain what the answer is. But in a performance test you have to parse the facts, you have to parse the law, and then you have to produce a work product as your answer. You don't just write a narrative answer. you have to write it in the form of a letter or in the form of a memo. So the good news is that now the California bar exam, 88% of our testing time is familiar. These are multiple choice and essay questions. In the old format, 66% was familiar and 33% was the performance test, but now it's dropped way down. So 88% of the exam is familiar, which is helpful. On the other hand, you could see a downside to this. The bad news is that now only 12% of the exam is based on your general skills of legal analysis, reading and writing, problem-solving judgment. Here's our client's problem. What's the answer? Now, most of the exam, 88% of the exam, is based on the memorized knowledge that you bring into the exam. And that's good if you're good at that, but it's a downside compared to the old format, which allowed you to show off your analysis and reasoning skills rather than simply your memorization. So I guess whether it's good news or bad news just depends on which type of question you might think you're stronger at. But the bottom line is the biggest effect of the new format to the California bar is that performance test questions have gone from the 6 hours to 1.5 hours, and that's a huge reduction in the amount of time you spend answering these questions. So my last big takeaway on preparing for the new format. How do we prepare for the new format? How does it differ from the old format? Well, we should, as with any exam, we should prioritize our studying with the test format in mind. I gave different advice under the old format than I give under the new format. The MBE is more important now. The essays are still very important and may start to emphasize more California state law. The performance test question is still there. It's still important. It's still 12% of your score. You certainly wouldn't want to walk into the bar exam completely unprepared for 12% of the test. But there's a big difference between 12% and 25%. So being prepared for the performance test is not nearly as onerous as it was previously. And I will say, to conclude my prepared remarks, I think the biggest benefit of the new format is simply the endurance part of it. The California bar exam has conformed to what our other jurisdictions are doing. It's only 2 days long. I think one of the reasons California bar exam was so difficult and had such a low pass rate previously is simply the physical and mental endurance of taking a 3-day test. There's very little other situations in life where we take 18 hours of tests over 3 days. That's physically exhausting and it's mentally exhausting. A 2-day test is much more manageable. Now, that doesn't necessarily guarantee that the pass rate will go up, but it can't hurt. A 2-day test is less rigorous than a 3-day test. And even though the bar examiners think that the results will probably be the same, I certainly think it'll help the examinees to only have to take that 2-day test. And that doesn't necessarily change the way you prepare in terms of memorization and test format, but taking a 2-day test, the standard 2-day length, that's a benefit. So that concludes what I had prepared to say. If there are questions in the chat, for me, I'd be happy to look at them and address them.